An Abuja Federal High Court today said the former Speaker of the House of Representatives, Dimeji Bankole, and his deputy, Bayero Nafada, had no case to answer regarding a 40 billion naira misappropriation charge. Justice Sulaiman Belgore gave the verdict while ruling on a no-case submission made by Bankole and Nafada over a 17 counts charge of criminal breach of public trust preferred against them by the EFCC. Both former lawmakers were accused of having approved loans not captured in the 2010 Appropriation Act. Their lawyers had on Monday asked the court to discontinue the trial and discharge and acquit them on the grounds that the prosecution did not provide enough evidence to justify the trial.
Pleased, and as is very, very clear, we had always said that we're not involved or interested in trial by media, trial in the newspapers, trial on the television. We're interested in a trial in court. You have all seen, you listened to a judgment that detailed everything and showed that the accused persons had absolutely no case to answer and that these charges had no basis in fact or in law. And we're very happy that the court has found that.
Remember that this is just one charge against the Speaker. This one relates to the taking of loans and the increment of their running costs. The other one regarding the other charge pending at the Federal High Court regarding the misuse of capital votes. That charge is still pending, and we are going to begin trial sometime in February or March or so. So that charge is still pending. This is just one charge. But let me summarize what the judge said, with which we disagree. One, that for them to have sat down, the legislature, to increase their running costs from 27 million naira to 42 million naira per quarter is a moral wrong. That is, they were wrong to have done that they were insensitive to have done that, but that it does not amount to a crime, because as legislatures, they are a third arm of government, that they have a right to do what they like with their funds. We disagree with that. The second reason he gave is that constitutionally, the Speaker and the Deputy Speaker, they have no control over the funds of the House, over the accounts of the House, that they have no control. In other words, the functions assigned to them in the Constitution do not include the operating of the accounts of the House. We disagree with that because the evidence presented by everybody said that without their approval, they cannot operate the accounts of the House. They were very clear. So, even if somebody is not constitutionally given powers to do something and he usurps the power to do it, he has to account for the usurpation of that power. So, these are the points we totally disagree with.